Welcome everyone to our session entitled Informal and Precarious Livelihoods During the COVID-19 Pandemic, Impacts and Responses. My name is Kelebogile Kuno, and I'm a researcher here at the Socioeconomic Rights Institute, and I'll be facilitating the session. I am joined by my colleague Loretti, who will be assisting me with the technical aspects of the Zoom meeting. So before we begin, just a few logistical announcements. I'm just going to ask everyone to please remember to keep themselves muted so that we can avoid any distractions during the session. If you are tweeting, please remember to use the hashtag PILG 2001 and to tag Seri in your tweets. Our Twitter handle is @Seri_rightssa. I've also enabled the panelists to share their screens. So please share your PowerPoint presentations when it's your turn to present. I also have your presentations, and so if anything happens, I'll be able to do that on your behalf should it be needed. So thank you everyone for joining our session. Let's begin with a little bit of scene setting. So it is widely recognized that the COVID-19 pandemic profoundly affected workers in the informal economy, which is defined by WIEGO as the diversified set of economic activities, enterprises, jobs, and workers that are not regulated or protected by the state. A majority of the world's workforce is in fact informal. The International Labour Organization estimates that 61% of the world's workers earn their living in the informal economy. In South Africa, it is estimated that around 30% of total employment is informal, and this is just under about 5 million workers. So comprising of workers like informal traders, waste pickers, who we also refer to as reclaimers, domestic workers, and home-based workers, work in the informal economy, according to the International Labour Organization, is often characterized by small or undefined workplaces, unsafe and unhealthy working conditions, low levels of skills and productivity, low or irregular incomes, long working hours, and a lack of access to information, markets, finances, training, and technology. Further, workers in the informal economy are not recognized, registered, regulated, or protected under labor legislation and social protection. Despite these exclusions, however, the informal economy is a significant component of our national economy in South Africa, with about 5% of South Africa's GDP coming from the informal economy. It is recognized that in South Africa, the COVID-19 context and regulations issued under the Disaster Management Act, such as the closure of public spaces and bans on trading, have meant that informal workers who depend on daily earnings and who lack legal and social protections have borne the brunt of the government regulations to control the pandemic. In particular, informal traders who did not trade in essential goods and services and reclaimers were prevented from earning an income due to the restrictions on movement. And many domestic workers who are protected by labor protections in South Africa, but usually work under informal conditions, were essentially left out, were essentially put on unpaid leave by their employers indefinitely, or dismissed by, some of them were dismissed by their employers. What's quite significant about the government's interventions is that they were focused on the formal economy rather than the informal economy. The COVID-19 Temporary Employee Relief Scheme, TERS, was created to provide income support for businesses and employers who were unable to pay their employees. However, it excluded all informal workers and the majority of domestic workers who, although they are covered by labor legislation such as the UI Act, were left out because it was initially open to employers who are registered and who were contributing regularly to the unemployment insurance fund. Further, many of these workers were unable to benefit from the range of relief measures that were introduced by the South African government, like food parcels, the unemployment insurance fund, increases in the social grants, and the introduction of the special COVID grant due to implementation failures. And so in response, worker organizations and trade unions implemented different strategies to mitigate the impact of the pandemic on vulnerable workers, which included mobilizing workers. In some instances, worker organizations approached public interest legal organizations, and they sought legal and advocacy assistance. And this is what we'll be hearing more about today. So the purpose of this session is to discuss the impact of the pandemic on informal traders, reclaimers, and domestic workers, and to explore the legal strategies undertaken by these worker groups alongside PILG's organizations to challenge the lockdown regulations, which adversely affected their livelihoods. So I'll now introduce the panel. So we have, firstly, we have Luyanda Hlatsoayo and Eva Mokoena from the African Reclaimers Organization. Both Luyanda and Eva are founding members and organizers of ARROW, which represents and defends the interests of reclaimers in South Africa. Their goal is for South Africa to increase its recycling rates and for reclaimers to be compensated for their labor, which forms the foundation of the country's multi-million rand recycling economy. Eva will start us off this afternoon, and Luyanda will hopefully be able to join us later on in the session. We also have Thandeka Chauke from Lawyers for Human Rights. Thandeka is an attorney at LHR, and she is the head of the Statelessness Project, which is a specialized project under the broader refugee and migrant rights program. After Thandeka, we'll have Nirishka Singh from SERI. Nirishka is a candidate attorney here at SERI, and during the COVID-19 pandemic, she worked very closely with informal traders and reclaimers, providing these groups with legal support. And last but not least, we have Kelly Kropman of Kelly Kropman Attorneys. Kropman Attorneys is a law firm focusing on constitutional and administrative law. It aims to provide representation on matters of public law for a broader group of people than would be available to traditional law clinics. So we'll begin the session with Eva Mokoena, who will be talking about the experiences of reclaimers during the COVID-19 lockdown. Each panelist will speak for about 10 minutes, and around 2:45, we'll hopefully open up for question and answers, and we'll take questions from the floor. So for the panelists, I'm going to ask you to please switch on your camera during your presentations. And for everyone attending the session, thank you so much for joining us. Please add your questions and comments to the chat as the presenters are speaking. And my colleague Loretti will collate these, and they will be shared during the question and answer session later on. So thank you so much. I'm going to hand over to Eva, who will begin the session for us. Eva, please unmute yourself.
Okay, sorry. Hi, everyone. Eva Mokoena, chairperson of ARROW. During the COVID-19 pest, when it started last year in March, reclaimers were not ready. To tell the truth, it's really hit them hard. I will say that because after 3 days, I received a call telling us that people are dying of hunger, and some will even go out to harvest some material because in some of the suburbs, they were giving them something to eat. So it was really a hard time for us reclaimers in level 5. But as ARROW, we collaborated with residents and some students from VETS, and even professors who help us to start a Bakabadi back that help them throughout. So that's the work that Arrow was doing all throughout, even today. Even some of the private companies like Chef with Compassion, it's still helping with veggies to give to reclaimers even today. That's the work that Arrow started last year during the first lockdown when it started at level 5. Thank you.
Thank you, Eva. So we'll hear more about the experiences of reclaimers during the lockdown when Leander joins us later. So now I'll hand over to Thandeka Chauke from Lawyers for Human Rights, who will be talking to us about the legal support offered to the Tshwane reclaimers during the lockdown. So thank you, Thandeka.
Thank you, Kelly. Just sharing my screen. Are you able to see my screen? I'll just maximize it.
Yes, we're able to see. Thank you.
Great. Let me just change the view. Okay, so my name is Thandeka Chauke, and I am the head of the Statelessness Project at Lawyers for Human Rights. Prior to that, I was based in the Land and Housing Unit of Lawyers for Human Rights and worked on a couple of cases representing and giving legal assistance to reclaimers at the beginning of the COVID-19 lockdown. So my presentation is focused on some of the key cases that we worked on during that time and some of the ongoing work we have around advocacy for reclaimers in the city of Tshwane. So in our experience of working with reclaimers in the city of Tshwane, we have noticed that despite the vast economic and environmental contributions they make, they are often disparaged and despised by authorities and the communities that they serve, if not outright criminalized. This has culminated in persistent harassment and abuse, in unlawful removal, confiscation, or destruction of their reclaimables, and unlawful evictions. This is also compounded by the fact that reclaimers generally in South Africa have inadequate legal and social protections. And what we noticed during the COVID-19 lockdown is that the pandemic and the lockdown itself, the measures that were introduced by the government to curb the pandemic, only worsened the plight of reclaimers. In April 2020, soon after lockdown was declared in South Africa, reclaiming activities were not classified as essential services. And therefore this meant that reclaimers were prohibited from working during level 5 of lockdown. So in April, after we attempted to engage with local and national government, we ended up launching an application in the High Court on behalf of 5 groups of informal reclaimers that are based in the city of Tshwane. This includes Mushroomville, Mooiplaas, Kloofsig, Clubview, and the Solomon Mahlangu group. In this application, we sought to challenge the lockdown regulations insofar as they did not categorize reclaimers as essential workers and therefore prohibited them from continuing with working and earning a living. Our main arguments was that the impact of this omission was severe on reclaimers, as it not only deprived them of the ability to make a living, but also to feed their families, to purchase medicine or access healthcare services in a pandemic, and particularly in a context where informal workers, including reclaimers, had actually been excluded from all forms of government support. We argued that reclaimers are indeed essential workers who do provide an essential service to the country, and the explicit exclusion from the regulations where municipal waste removers were acknowledged was unjust and discriminatory. The Minister of Environmental Affairs in her affidavit did acknowledge the extreme hardship that waste pickers were facing and that under normal circumstances, they played an integral role. But the minister disagreed that they could be classified as essential workers under the lockdown and argued that it would be unsafe to allow them to return to work. Ultimately, the court also decided it would be unsafe to allow the reclaimers to return to work, especially when at a period where there was limited PPE and increased efforts to have people stay at home to avoid the spread of the virus. However, as a compromise, shortly after the court hearing, the Department of Environmental Affairs and some private companies did take the initiative to try and get food relief or relief packages for reclaimers distributed. There were still issues with this because undocumented reclaimers, for example, still could not access these relief packages, and most of the reclaiming groups had to end up relying on civil society groups or charity organizations and religious groups for assistance with food. A month later, almost a month later, South Africa then moved into level 4 of lockdown. And this time, the new regulation cited reclaiming or recycling as a permitted service. This came as a relief to the reclaimers who had been without an income for several weeks. But within the first week of returning to work, we received a complaint from one of the Tshwane reclaimer groups that their trolleys had been confiscated and thrown into a waste removal truck by TMPD officials. And the officials had found this group waiting alongside Solomon Mahlangu Road and confronted them. They told them they were not allowed to be on the road with their trolleys and quote rubbish, and instructed them to go home. The reclaimers explained that the new regulations permitted them to resume work, and then the officials demanded to see their permits and identification in the form of passports or ID books. After this incident, we tried to negotiate again with the city of Tshwane for the release of the trolleys, and also tried to secure a commitment that TMPD officials or local authorities would not interfere with the reclaimers as they were trying to go back to work. After not receiving a response from the city, we launched an urgent application to seek the same relief. The first thing was to get back their trolleys. The second thing was for an interdict against the city of Tshwane and TMPD officials from harassing and interfering with the reclaimers' work. And the third, to declare the regulations that required reclaimers to apply for municipal permits unconstitutional and invalid. Now, you'd remember that to apply for a permit under level 4, it required applicants to submit an application to the municipality and to attach a valid ID book or a passport and a visa or refugee or asylum seeker permit. So we argued that the purpose of the COVID-19 lockdown regulations was to curtail the spread of the pandemic and not an opportunity to investigate people's documentation and immigration status. And we argued that this was not only unconstitutional, but also xenophobic and discriminatory. The application was dismissed on, I think, the grounds of urgency, but before the application had been heard, we had at least managed to secure this commitment from City of Tshwane that the reclaimers could go back to work without interferences, and that the trolleys would be returned, which they were, and that they would be entitled to some form of compensation for the damage to, or loss to some of the trolleys. And this is another case that we dealt with during lockdown in consultation with some of the reclaimer groups at the beginning of lockdown. Many voiced their fears of, dying from the pandemic or dying from hunger because they had been locked out of their livelihoods. This included Justice and George, who out of desperation took the risk to leave their homes in early April 2020 to look for reclaimable goods to sell and get some money for food. And unfortunately, they were arrested for breaking the lockdown rules. And instead of being allowed to pay the admission of guilt fine, they were in fact detained at Kgosi Mampuru for 3 months without access to lawyers and without access to medication. They were, put in an overcrowded cell, ironically then exposed to COVID-19, having to sleep with a group of 48 other cellmates with no food and no blankets. So we launched a social media campaign under the hashtag Free Justice and George to get the attention of the Minister of Correctional Services and the Minister of Justice on this situation. After not receiving any attention to the matter, we had to launch an urgent habeas corpus for the release of these two reclaimers. And on the 8th of July, the judge then ordered for their immediate release. And surprisingly enough, they were released with 7 other people who had been arrested on the same day. This just goes to demonstrate some of the difficulties that reclaimers have to deal with on a day-to-day basis. And then generally, some of the cases we handle are related to evictions and the right to earn a living for reclaimers. We are currently involved in quite a number of these eviction cases under City of Tshwane. The trends we have noted is that there's usually an issue of destruction of reclaimable goods or materials.
Permits were issued to traders in a way to sort of, in a way the state tried to regulate who is trading and legitimize them in some form of way. But this permit system became out of use a few years ago, actually. And so when it came down to trying to establish who had been trading in certain areas for a long time to try lean on their legitimacy or their recognition by the state to, you know, combat and work with these regulations, there was nothing reliable that traders could rely on in doing this. A lot of people produced expired permits and explained that the system was no longer in place. And in the case that I'll talk about in a little bit, we tried to retrospectively show that this is some kind of recognition or legitimization or anything to show that traders had been there for a long time. But that was one of the main challenges that we faced before and after COVID. Okay. So, I mean, like I said, the COVID response and the lack of recognition really clamped this down when it came time for the lockdown. The lack of regulation of informal work also led to a lack of recognition of informal workers and their essential services that many of them provide during the COVID-19 pandemic. As the regulations were amended, it became more and more inclusive, but especially in the beginning of the lockdown, it really exacerbated the struggles faced by informal traders, especially informal traders who traded in fresh produce or cooked food. One of the things that we ended up talking about during the case that just came to mind was that with cooked food, at one point you could only get cooked food that was delivered to your house. And this was something that obviously didn't consider informal traders at all. And so the question then becomes, how do you then help people who rely on this cooked food and the people who make it? And how do we then engage their rights in a way that doesn't limit them because they don't have access to like a Mr. Delivery or Uber Eats? That was definitely a part of the problem of the COVID-19 response to informal traders. And then just to elaborate a bit more on the scope. So we assisted traders in Johannesburg through our litigation work in the case that I'll elaborate a bit on in a few minutes. And we also assisted traders in eThekwini. The difference in the municipal approaches was something that was stark, and it stood out to us for many reasons. In eThekwini, what we were trying to do was not any litigation work per se, but assert and advocate for traders' rights by correspondence and putting pressure mainly on the municipality to reopen markets, especially for trading markets that were specifically for food and for vegetables, like wholesale produce and that kind of thing. It became an issue because the traders there were trying to assert their rights and they were themselves also scared of the pandemic. And so they volunteered to implement all kinds of social distancing measures, as well as health and safety measures, and reduce their capacity to accommodate social distancing and that kind of thing. Even when they asserted these ideas and suggestions to the municipality, which meant the result of which would mean they would lose income, they were still met with a harsh no in terms of reopening their markets. And so it was persistent communication and putting pressure on the municipality to slowly begin opening their markets. We were successful, but it did take a lot of time. And during that time, traders were deprived of income they needed, but also should have been allowed to under the regulations. So there's that disjuncture that really, in my opinion, I don't know how far I can base this in what happened, is in the way traders are framed in the minds of the people who are giving them access to this right, and also just the assumption that what they're doing is not essential, or who they're providing services to are not essential, which is incorrect for many, many reasons. Okay, so this is the case that we worked on, HCI House Investments versus the City of Johannesburg. And it tried to do two things. The applicant in this case is a building along the affected trading streets, privately owned, and it brought an application on an urgent basis, which tried to enforce COVID-19 measures amongst traders. It also tried to prohibit trading on the streets in downtown Johannesburg permanently. So the permanent part of the order or the request of the application was part B, and the urgent enforcement of COVID-19 protocols was part A. The basis, and this was interesting, of this application was that the applicant suggested that the traders and their customers posed a health and safety risk to the people in the building of the applicant. And this is interesting for a lot of reasons, because it means that the applicant saw the customers of the traders and the traders themselves as the same, as one group of people. And it also shows that the pandemic was a useful way to ignore the legitimacy of the people who had been trading there for a very long time. In their papers, they do make mention of the fact that these traders have been there since the early 90s. But during the way the application was brought, the pandemic seemed to undercut that. Okay, so really important factors to note is that before this application was brought, traders themselves were eager to get back to work. And because of this, they self-imposed rotations and health and safety measures, as well as social distancing between their stores, well before this application was brought. And this was not dealt with at all in their papers of the applicant. It was already something very difficult for traders to do because it was a very congested area prior to COVID, but traders came together, especially under CITES, and were able to do this because of their desire to really start earning an income again. At this point, there had been several weeks without any income for many of these traders. So it really is important to note that, because it mitigates how this perception that traders don't have the agency to take measures like this. And it also really highlights the need to give traders the opportunity to assert their right, because the assumption that they won't is really something that held this application back. Okay, so the city was brought into this case because of Sari's involvement. I should say that we only found out about the case because an enforcement officer mentioned it in passing to one of the CITES members. And if it hadn't been for that, we would never have known about this case, and the judgment would have been granted without us even acting for the traders. It's very difficult to think of informal traders as one group of people, but the application does do that. But in essence, what you're doing is affecting the rights of thousands of people who are trying to work. So they claimed that the gatherings of people, of traders as well as their customers, amounted to a public gathering, and also claimed that the use of sidewalks, which has been done for decades, was a problem. This was something that we had to deal with when defending the rights of traders in this matter. And what we did was basically enlist one-to-one to create the map that's on the slide in front of you. And basically what it did was measure out the streets of the affected areas and determine how many stores would be appropriate with social distancing measures. As I said, traders were already using masks and sanitizers and requiring their customers to wear masks. So those things weren't weren't necessary for us to further enforce. But this map was something that we were able to present to the court as a way to make sure that traders could still stay there without posing a health and safety risk, as the people claimed, as the applicants claimed. So all of these things were taken into account by the court, and ultimately it was made an order of the court that the social distancing and health and safety measures were implemented. The most important thing, though, is that traders were not removed, and they're still there, which is great. Yeah, I think that's all I have to say about that. That's my presentation. Thank you.
Thank you so much, Narishka. We are going to shift our perspective a little bit from workers who operate in public spaces to workers who operate in the private home. So next we'll have Kelly Kropman from Kropman Attorneys, and she'll be telling us about the challenging the exclusion of domestic workers who are not registered with the UIF from the COVID-19 temporary employer-employee relief scheme. So Kelly, if you're ready, please go ahead.
Thanks. I just want to confirm that you can hear me.
Can't hear you.
Yeah, that's what I wanted to confirm. How about now? Anything? Any better?
There you go. Sorry.
Okay.
Great. Thank you.
Excellent. I'm going to share my screen and begin the slideshow. I prepared a slideshow. It's not really my usual. Hi, everyone. My name is Kelly Kropman. I am an attorney in private practice, but I come from LRC. I want to talk about the challenge that my firm did in support of 3 civil society organizations to challenge the PILG provisions as they were created immediately as hard lockdown was created. So the background on this was that domestic workers and other precariously employed people were completely excluded from the provisions of the temporary employer relief scheme, which everybody knows about. But I'll just give a little bit of background on that. PILG was created as a form of social assistance to those who were employed and therefore not able to access social grants, but who were not able to earn because of the hard lockdown. There were many, many problems with the way that this scheme was created at the outset, and that problem specifically affected those who were in these sort of precarious places of employment. So our focus was domestic workers, as well as people working on farms and other people who would probably not have their employment status registered properly. So the bottom line for all of that is that domestic workers, as well as other precariously employed people, were vulnerable before COVID-19 and before the hard lockdown. The state responded with PILG, so I've just jumped ahead, and the response obviously came from a good place. We cannot chastise the state for making the attempt to do something that amounted to social welfare for people who are employed. That is admirable, and we're very glad that they did that. So PILG operated in terms of giving a proportion of a worker's wages to be paid to the employer upon claiming when the employer was no longer able to make payments for those wages for the workers who could no longer work, or that their hours were dramatically reduced. This was on the basis that the employer applied for the PILG scheme on behalf of their employees whom they had registered for UIF and were regular contributors. So the requirement to qualify was you had to be an employee whose workers were UIF registered and the UIF contributions were registered. There are a number of problems with that, principally that the employer is the person that is placed in the position to apply for the scheme. If they choose not to, the employees, the workers, had no recourse. So I keep on jumping ahead, which is why slides are not my bag. but the money would then also be paid directly to the employer, and there was no mechanism to monitor whether or not these payments would trickle down towards the workers. Only the employer could claim, and only the employer's bank account would receive this. The manner in which that money was then distributed to the employees in terms of the TERS calculation was not factored in. Nobody knew whether or not employees were paying fairly or pocketing the money for themselves or paying only certain of their workers or what have you. And again, we get over and over back to the fact that there are a great many people who, through no fault of their own, are not registered for UIF, even though they should be. So we were approached by, I was approached by the Casual Workers Advice Law Clinic to represent the Casual Workers Advice Office, and then ISRI Domestic Workers Alliance and the Women on Farms Project, which is based in Stellenbosch, to bring about a challenge to the TERS. Initially, that challenge was in the form of letters of demand, but the ultimate relief that we saw was, in practical terms, twofold: that workers could apply for TERS themselves, and that UIF contributions or UIF registration was no longer a factor in whether or not somebody qualified for the scheme. Basically, the only thing that would be necessary to qualify you is that you've been employed directly before the hard lockdown took place. So our strategy was this: I wrote many letters of demand in conjunction and with the amazing assistance of the Casual Workers Advice Office Law Clinic unit. And then we would approach the labor court. And the basis of our argument was that the TERS scheme amounts to social relief. It's a form of social welfare. It is therefore informed by Section 27(1) of the Constitution. However, the arbitrary provisos of both UIF registration and contribution, and that the employer is the only party that may claim, amounted to arbitrary deprivations that were not rational. So our strategy in all of this was to principally take the course of judgment and remind the state that this is still in play and they have to comply with it. We started with the Casual Workers Advice Office started with 2 letters of demand. They were very quickly responded to, and the response was, please give the Department of Employment and Labour another indulgence. Please understand our position. We're trying our best. We understand your plight. But there were no hard undertakings to remedy any of the concerns by the Casual Workers Advice Office, who was the primary organization that sort of began this process. We then went on to formalizing what it, before you write a letter of demand, you've got your notice of motion in your head. So we went into the regulations as we saw them and started devising. So I should state, at the point where we considered going into litigation, I had appointed counsel. So now when I'm speaking about we, I'm speaking about a much larger legal team. The conceptualization of the relief sought was the declaration of invalidity on urgency and the provision for reading in for the sections that would allow employees to claim for themselves and to declare invalid the provisos that UIF contributions and registration is necessary. So taking the principles of causa, as I said before, TERS takes a form of social welfare, therefore UIF contribution requirements are arbitrary. So then our key challenges, as there are with any form of strategic litigation, is finding pro bono counsel. Fortunately, the unbelievable team that I had, I'll go into a little bit of detail of who they are later, I was really standing on the shoulders of giants in this, but we had excellent counsel, and then who our respondents would be. So how far down the value chain between ministers, presidency, Minister of Cooperative Government, DG of Labour did we want to go, and we felt that it was best placed to keep it just at the ministerial and presidency level, so as not to clutter the amount of people. Ultimately, we had the Office of the Presidency, Minister of Department of Employment and Labour, and Minister of Cooperative Government as our respondents. So, holding people accountable on urgency, we really don't want to clutter up the header of your case. Then there was a real question about which courts to approach. At this point, it was still level 5 lockdown, and there was serious consideration and a little bit of clients really wanted to go to the Constitutional Court and petition for direct access. I was very hesitant to do so. I think it was the right idea. Urgency and direct access during hard lockdown, the Constitutional Court's attitude had already been through 2 previous applications that had been attempted at that point. Was one of there are more competent forums, and a case for direct access has not been made. The purpose behind clients wishing for an application for direct access or a petition for direct access was that there would be a final in nature response to this. Difficulty is it would take a very long time to actually get a date, even on urgency, before the Constitutional Court at that time. And the Labour Court was in fact the competent court to hear it. So ultimately, we decided to go by way of the Labour Court in Johannesburg, which was exciting for me because I had never gone to the Labour Court before, and they have their own rules and procedures, and it's very interesting. The next question was timelines and what would be reasonable. We decided to take a stance of long urgency. So I think there was a turnaround time between notice of motion and answering affidavit. I think there was a 2-week turnaround for that. So there was plenty of time to deliberate, discuss, and ultimately hope for a settlement. What we really perceived was that we would only be in discussion with the Department of Employment and Labour and ourselves. The presidency and the Department of Cooperative Governance was really just there as interested parties. And of course, the delineation and the delegation of authority that came from the Disaster Management Act. However, everyone opposed. So at the time that I was litigating this, I was a sole practitioner. I have a wonderful assistant, and that was that. So, you know, getting letters of opposition from the state attorney, from private attorneys, for the Office of the Presidency, Cooperative Governance, and the Department of Labour was a little intimidating, and I must say I had a moment. Also, the Department of Labour instructed Health and Cheadle, the Health and Cheadle. So again, being a sole practitioner, really little, and having very limited resources, it was a little bit of a feeling that you'll get as a practitioner from time to time. He was ultimately really, really easy to deal with, really reasonable, and it reminded me, as many of you will know, that working with a really great attorney as an opposition moves matters along really swiftly and makes the process a lot easier because you don't have to keep on second guessing what somebody will do. We wanted very badly to get to a point of settlement. There was a lot of to and froing about this. There was concerns about fraud and what if the relief that we wanted we were going to get. That relief, the Department of Employment and Labour really did feel was going to lead to a lot of fraudulent claims. They didn't understand how to mitigate it. This is a very limited amount of money. You know, this is all with them filing a notice of intention to oppose, and everyone's sort of sitting under the thumb here. We had the clock ticking. There was also a view that some of the things that we had asked for way at the letter of demand phase, such as employees being able to apply themselves, the UIF for TERS, those regulations had been published on the Department of Employment and Labour's website, but never gazetted. So we persisted with our demand in our notice of motion that these ultimately be granted in terms of a court order. Department of Employment and Labour persisted with their contention that if these regulations are published anywhere, then they are enforceable. But if you spoke to the UIF hotline, they had a different story. There was a lot of breaking in the chain. So we ultimately convinced them to publish a series of amendments to the regulations in the Gazette, which felt like a very small but significant victory for me. And still the ultimate chink in the armor, the ultimate thing that was holding us back was the necessity for people who are not registered for UIF to be able to claim the relief. So I got a phone call from somebody at 10, 11 o'clock at night, the night before the answering affidavit of the parties was due. And the night before, they sent us a regulation that ultimately was exactly what we asked from the beginning. And they said, if you withdraw, we'll publish this first thing in the morning. So we did. Unfortunately, there was also conditional on this, was for each party to tender their own costs. But that was definitely something that everybody was happy to live with, if that meant that really thousands of people could now go and apply for any form of relief that they weren't able to access before. So for the period that PILG exists, people have been able to access some form of relief. There's some formalities that have to get some confirmation from employers that they were employed, but this didn't necessarily lead to penalties on the employers. I think it will down the line, but there was an incentive for employers to be able to allow these people to apply on their own. So ISWE, Domestic Workers Alliance, and the Women on Farms project then created sub-projects to assist their constituents in applying, providing IT support, because this could only be done online on the UIF website, in a different process than was available to everybody else applying for TERS, nonetheless. So there was extended training to sort of assist people in situ to be able to apply. And at the end of the day, it was a very, very happy story, and there was some impact. We didn't get our day in court, we didn't get our court order, which would have been really fun, but at the end of the day, there was real impact, and I had a nice feeling about it. And so that's my story about urgent impact litigation. Thanks.
Great, thank you so much, Kelly, for that wonderful presentation. We're going to begin the question and answer session now. And just a few comments from me. I think it's really interesting to see the commonalities between informal traders, reclaimers, and domestic workers during the pandemic, the commonalities of their struggles during the pandemic. I think it all boils down to a lack of recognition of the contribution that informal traders, reclaimers, and domestic workers provide the country and the economy. And as a result of this, this lack of recognition, there have been really long-standing issues that were exacerbated by the pandemic. And I think the speakers really touched on some of these. So, for example, the lack of social protections for informal traders and for reclaimers. People were left without an income. People who, as Narishka explained, really depend on almost a daily or a weekly income, were deprived of an income and essentially did not have any access to an income or a way to put food on the table during those weeks, even though there were some of these interventions by government. But because of implementation problems, we can really tell from what the speakers have shared that millions and millions of South Africans really bore the brunt of the pandemic. What's also really interesting is to hear, I think in the earlier sessions, there was talk about the use of litigation, but also exploring other avenues. And we can see, I think Kelly just mentioned now that really when it came to when the victory was won, although it was in an unexpected way, it was really important for organizations like Women on Farms and ISWE Domestic Workers Alliance to really provide a different kind of support for their constituencies in actually accessing justice. And I think there are more examples as well from the previous speakers. So from the examples with the reclaimers about how really they mobilized themselves and provided support in other ways while the litigation was going on. So the distribution of food parcels was one example, but also I think what Narishka was talking about in terms of informal traders organizing themselves and preparing themselves to work in public spaces in terms of the health and safety regulations really shows how this interweaving of litigation as well as other efforts can really help to move some of these struggles forward. So I'm just going to open up to question and answers, and we'll take questions from the floor. I think I don't know if we can raise hands, but I think we can, yeah, I think what we'll do is for anyone who has a question to unmute themselves and put on their camera if they want to, and direct a question to one of the speakers. So there's a question from Loretti. Please go ahead with the question.
Hi, I hope everyone can hear me. I actually have two questions, and they're sort of related to one another. The first one was for Thandeka. I know you were saying in the beginning there that you were trying to get basically the sorry, I'm forgetting the word, but the overall solution. I want to know, what was the overall solution for reclaimers who didn't have proper documentation and their ability to not apply to the municipality to work? What in essence happened to those people? Was there ever a solution found? Because in your presentation, I didn't hear a solution for those people. That would be great to hear. And then I think that ties into Kelly as well. I see that TERS has allowed foreign nationals to also apply. But I wanted to know, regarding foreign nationals who had employment prior to COVID, but also no documentation, were they ever brought up in the conversation? And if so, what was perhaps the solution there for those people, if they could perhaps prove that they were employed prior to COVID, but just had no formal documentation? I hope my questions made sense. Thank you so much.
Great, thanks, Loretti. I think we'll start with Thandeka and then go to Kelly.
Thank you, Kelly. So the quick answer to your question, Loretti, is that the regulations then changed again shortly after that. I think when we moved into level 3, they completely scraped the requirement for permits. So it no longer became an issue. But our arguments around that was that if there was a requirement for a permit to regulate people's movement during the lockdown, it didn't have to be based on identity documentation. It only required, the workers to just record who they are and where they stay for purposes of, contact tracing, because I think that was the whole reason for having an idea of who is up and about during lockdown. But I think it's still a bigger issue that still needs to be addressed in the context that many of the non-citizen reclaimers that are in South Africa to work and who have come to South Africa to try and make a living and to send money back to their families at home are still undocumented and still struggle to access the immigration system because there's no sort of permit that they can apply for. They don't qualify for work permits because they're self-employed, and they don't qualify for business permits because they're in the informal sector. So these are other issues that still need to be dealt with at a systemic level.
Hi. So I've changed my speaker system. Can I get a thumbs up if you can hear me?
I think if you could speak into can you speak into your mic a little bit more?
How's that? Okay. So our aim was not specifically focused on looking at foreign nationals, nor looking at foreign nationals who were not in the country with a status. I know that there was a lot of sort of advocacy around foreign nationals who were in the country with status because, I mean, the UIF honestly had a situation of the computer says no, so we're not going to do this. There were a lot of glitches in the computer. With regards to foreign nationals who were not in the country with a specific status or eligibility to work, I believe that they could go by way of the tier scheme that was created for people who were not UIF registered. But to the extent that they were paid out, there were very, very uneven reports. I did speak with a colleague who had intention of challenging that, but ultimately didn't. And I think that there was sort of negotiations on case-by-case bases with that regard, but I think that there were probably thousands and thousands of marginalized people that were excluded. I'm sorry, I can't give a better answer, but yeah, I think people were marginalized and vulnerable and treated as such.
Thanks, Kelly and Thandeka. I think there's a question that's in the chat. So it's a question from Lauren Royston. It reads, going back to the plenary discussion and the state's relative openness, I'm wondering what the reflections of the panel are on the gains made in the COVID context and what these might herald for the short and medium term future. So I think this question is addressed to all the panelists. So Thandeka, Nareshka, and Kelly. I think Eva is also still here, although she was having some technical issues earlier. So Eva's still here. So all the panelists, this question is directed to all of you. Yeah, anyone?
All right, I'll go first. I was very surprised by the state's openness and willingness to engage. I think that there was a lot of uncharted territory for state departments, and they knew that there was going to be a windfall of litigation, that all the organizations had a lot of vulnerable people that they were representing that were going to be specifically targeted. And for that reason, what I saw is that the state was trying really hard to analyze and address the issues brought by the threat of litigation, because the threat of litigation still had to be made. And there was also sort of public sentiment that needed to be saved. So you'll see that the state only opposed litigation that they knew they could win, and they were very open and engaging on matters where there was a chance they might not. And so I took a slightly jaundiced view on the approach that the state took in terms of litigation, in that they were trying to save face largely. I mean, you look at the sort of very, very early litigation that the state did oppose. Examples of that was when there was an application from the Durban faith-based organization to have the mosques reopened because the lockdown constituted an infringement on the rights to freedom of religion. On the basis of the limitation of rights, that was very clearly not something that the state was going to lose. There was other little bits and bobs of litigation that the state opposed, but when it was sort of real urgent, real rights-based issues where there was going to be serious and irreparable harm caused, the state capitulated a lot quicker than they ordinarily did. But my take on that was that there was a need from the state to maintain public sentiment and maintain public unity and positivity. So if the state is taking proactive steps, everybody would continue to feel positively towards it. I take a very jaundiced view though.
Okay, I'll go next. So in answer to this question, I think it's a bit of a mixed bag. During the case, the HCI litigation, during the process of it, the city were the people who called a meeting between all the parties to try to resolve it without pending litigation. And I think that was because they saw that any outcome of this case in favor of either the applicants or the traders would create an obligation on them in some respect that they weren't already doing. And so there was openness in that way, whereas before in previous litigation, I think it's pretty well established that we've had to bring the city to do something with a court order. So that's in one sense. In another, especially in eThekwini, in reference to informal traders, specifically with food informal traders, grocery informal traders, there was also a lot of outcry from communities who were being deprived of the sale of these grocery items. And so I saw a lot of news items and media articles about people, just everyday people, really advocating for the rights of informal traders indirectly by trying to say that they needed to purchase these items, you know, urgently. And so I think there's a culmination of different things that facilitated the openness of the state, and the presence of the pandemic made it unavoidable because it was beginning to impact many people, more than just the traders themselves. In terms of their right to trade, it was becoming a livelihoods issue in the very, very various and nuanced ways, and it was becoming unavoidable because of that. I don't know if that fully answers your question, but that's all my comments in terms of that thing.
Okay, sorry, I'm in the dark now, not shady. I'm in the house. Outside there is a lot of noise. Okay, just to answer the first question, for reclaimers, the government didn't do much, I won't lie, because even the food parcels that were donated by industry, it was choosing people. Only South African were supposed to get that food. They were separating us as reclaimers. So nothing, I'll say nothing really helps from the government. Then the second questions, no, Loretta, they didn't help. We've got residents, as I'm saying, and other organizations who helped, and even the industry, like Coca-Cola donated the PPE, like gloves, sunlight dishes. So that's how we got PPE. But the government didn't even help. Even with the COVID relief fund that they were giving, not all of the reclaimers did get that. Not all the reclaimers did get that. Only few did get that. So it's like that. That's how our government are doing things. So I don't know if I've answered all the questions. Thank you.
Thandeka, do you want to give it a go, or were you covered?
I think just to add, I think I agree with Eva's perspective. What I think did come out of the experiences of lockdown is the fact that reclaimers have been sort of hidden in plain sight all along. And I think some of the issues that came up during lockdown, during the litigation, sort of brought light to the multiple issues that reclaimers struggle with on a daily basis, and the things they've been fighting for: recognition, for compensation, for PPE. The request for PPE had started even before the pandemic, but now they've become even more urgent given the context of working where there's a global virus. I think the one thing that came out of the litigation that I found quite compelling was the one affidavit by the Minister of Environmental Affairs, in which she actually does acknowledge the important and critical role that reclaimers play in society and in the waste management system, but more needs to be done. We need more commitment. We need more involvement from local and national government. We need to address the policy issues. Yeah, so I think that's what I can say about that.
Thank you all. So this one last question, which is similar to the question that Lauren had asked from Zanele. It's not for anyone specific. I'll just reword it a little bit since it's addressed to everyone on the panel. So Zanele is asking, given the state's openness to litigating on matters concerning informal workers, do you see a progressive future for the rights of informal traders, reclaimers, and domestic workers? Just also considering the public perception of informal workers in general. So I think this is probably our last question. And to Thandeka, Eva, and Kelly and Narishka, if you could please answer this question, but then also if you could possibly just give your closing remarks as well about the future of informal and precarious workers, given the experience of the COVID-19 lockdown.
I'm happy to go first again, if that's okay.
Go for it.
And my webcam has died on me. I don't know why. So I think that South Africa has in principle committed to a lot of the recommendations and reports of the International Labour Organization, which has then in turn recognized how the gig economy and informal work has overtaken traditional forms of work. I think that the Department of Labour wishes to take a more progressive stance on what constitutes work and what constitutes a worker, as opposed to a self-employed person. You look at what's happening, and I know it's a very strange angle to look at it, but you look at what's happening with regards to the film and television industry in South Africa, which is starting to recognize the need for, the Department of Labour rather, is starting to recognize a need for sectoral determination. Although almost everybody in that sector is a freelancer or a self-employed person, there is need to regulate. I think if we can, if civil society can maintain some momentum, there can be some pressure applied to the Department of Employment and Labour to consider similar such sectoral determinations to provide protection to other groups. Domestic workers do need some recognition for the fact that their working environment is very different from others. And so there should be a sectoral determination that gives specific recognition to that kind of work. And I think that if there could be some protection, it might just come from the Department of Environmental Affairs, but for reclaimers, because of the essential value that they provide to everyone in the country, it's really undeniable. We can use this as a leaping board because there is evidence for the situation that people live in, and there is evidence for what could be better. And I think some of this litigation is very evident. It makes that very plain, rather.
Thanks, Kelly. Eva Tandeka.
Okay, so I think to answer this question, I think it's good to be a bit positive, like optimistic, but also realistic. I think that while we've highlighted how important informal trade is, the stigma still really does exist in the minds of a lot of people who don't engage with informal work at all in their daily lives. So I think what it has done, what this pandemic has done, is tear the lid off things that were blocking, sort of like a glass ceiling that was blocking informal traders from being recognized and seen. Very similar to what Tandeka said, with waste reclaimers being hiding in plain sight. Informal traders are largely the same. You can see them everywhere you go if you go into certain parts of towns all over the country. But recognizing them for what they do and how important the work is that they do is something different altogether. And I think we're on the way there because of the way things have changed, but there's still a long way to go before you can think of informal trade as properly recognized and accommodated in city spaces. So I think, yeah, it's a bit of a yes and no situation. And then Loretta, in terms of your question, our client in the HCI case was cited, the South African Informal Traders Forum, along with ATO, the African Traders Organization. I think I might have gotten their abbreviation wrong. But what they did was, within the leadership of their organizations, their respective organizations, and together, spoke with the traders and came up with this plan together. Their decision to implement a rotation and social distancing and all the health and safety stuff couldn't have been done if the traders themselves weren't on board. And so they just relied on the organization structures to implement it and organize it from like an administrative point of view, but not from a decision-making point of view. And I think that's really important. So thank you.
Let's go to Eva, who's battery's dying, so let's give you an opportunity before you leave us. Eva, are you there? Eva, are you there? Okay. So maybe we can go on to Thandeka for your closing remarks and answers to that question.
Okay, so in my opinion, I am optimistic about it. It's been achieved in South America, for example. There are good lessons to be learned from Brazil, from Colombia, good models that we could adopt in South Africa. In South Africa, at least civil society has laid the foundation for more progress towards, formalization and recognition of reclaimers. But what we need is the decision makers and the policy makers to also come on board. So one, I do think it is achievable. I think it will take time, like all other things in South Africa, but it is inspiring to see the work that, for example, organizations like Arrow do, and Project Zion, that are working to try and organize the reclaimers and to shed more light on the issues that they have and the kind of sustainable solutions that can be adopted.
All right, thank you. So we're nearly at 3:30, which is the end of our session. Yeah, just to reiterate what Thandeka, Kelly, Mirishka and Eva have been talking about in their closing remarks, is that we can be optimistic but realistic. That the experience of the pandemic, the advocacy that was carried out by these informal worker organizations alongside others really served to highlight these very long-standing issues that these different worker groups have been experiencing over the years. And so I think the advocacy messages are loud and clear, but what I'm hearing from everyone else as well is that the policymakers, the decision makers, government has to come to the table and meet us halfway, because it's going to be impossible to be able to really afford these worker groups the rights that they actually have under international and the Constitution, as international law and the Constitution as well, for those rights to be realized and for them to benefit from the social protections that should be given to them. So I want to thank everyone for joining our session this afternoon. It was really interesting to hear the different perspectives of these informal and precarious workers and what happened during the COVID-19 pandemic. I'm just going to take this opportunity to introduce the next session as it was left out on the program. So after the tea break, there will be a 1-hour workshop facilitated by Lucy Draper-Clark. So it will start at 3:45. And it's entitled An Introduction to the Nervous System, Mindful Movement, and Mindful Awareness Practices. So Dr. Lucy Draper-Clark is a retreat facilitator, mindfulness mentor, and researcher practitioner in the field of mindfulness and compassion. After obtaining a doctorate in mindfulness and teacher education, she now offers public courses on mindfulness and compassion. And she's also an associate researcher and supervisor at Wits University. I'm just going to read the little blurb because I think it's really important as we're talking about all of these issues and all the efforts that people in the public interest legal organization have been carrying out throughout the pandemic, that we need to give time to think about our mental health and just be aware of mindfulness and take care of our own selves as we're fighting the fight. So it says, during this time of disconnection, grief, and overwhelm, many social justice activists are burning out. The work is hard and feels never ending. often the most committed activists are those who have experienced suffering themselves and are driven by a lifelong passion to protect others. So I'm not going to read all of it, but essentially what we'll be looking at in this workshop will be, it's a self-care workshop, and she will be offering us simple contemplative practices to support the nervous system when it is being subjected to stress and trauma. And participants will learn to shift from survival brain dominance and bring the prefrontal cortex online. She'll also be offering a 30-minute workshop tomorrow morning called Embodied Self-Compassion Practices. So I just wanted to take this opportunity to encourage everyone to join that session after the tea break. But from myself and from Seri, thank you everyone for joining us this afternoon, and thank you so much to the speakers for really wonderful presentations.